HR professional, when was the last time you read your entire employee handbook cover to cover? Because buried in that document right now are 3 potential missing sections that federal agencies use to build unfair labor practice charges against companies just like yours. These aren't obscure technicalities. I'm talking about gaps that could turn a $5,000 handbook into a $150,000 liability. And the worst part? Your managers are creating evidence of these violations every single day. I'm Alex Castro, a Florida licensed labor and employment attorney with AXC Legal located in Fort Lauderdale, Florida. I help South Florida businesses build legally compliant employee handbooks and defend against National Labor Relations Board charges that start with handbook violations. Remember, this is general information only, not legal advice. Every employment situation is unique and requires individualized evaluation. Your handbook probably looks professional. It's formatted well, it covers the basics like attendance, vacation time, anti-harassment policies. You had it reviewed when you started the company, maybe updated it once or twice. Every new hire signs an acknowledgement form. On paper, everything looks buttoned up. Here's the problem. Federal labor law changed dramatically in 2023, and the NLRB is now targeting handbook language that was perfectly legal 2 years ago. Employment attorneys know exactly which sections to look for when building unfair labor practice and discrimination cases, and they're finding the same 3 gaps in handbook after handbook. What HR sees as complete policy coverage, plaintiffs' attorneys see as missing liability shields. These aren't accidental oversights. These are systematic holes that experienced legal counsel specifically exploit in labor and employment charges and litigation. Today, I'm breaking down the 3 most critical sections missing from most employee handbooks and showing you the exact language you need to add before these gaps become the foundation of a federal charge against your company. Your employee handbook has 5 pages about how you discipline employees. It lists verbal warnings, written warnings, suspensions, and termination procedures. Every infraction is clearly spelled out. Your managers know exactly what to do when an employee breaks a rule. But here's what's missing. Nothing in your handbook explains what happens when a manager violates company policy. Nothing explains what happens when a supervisor fails to document discipline properly. Nothing holds managers accountable to the same standards you hold employees to. Most HR teams think their general policies apply to everyone. The handbook says all employees must follow these rules. So that includes managers, right? That feels like sufficient coverage. But here's what employment attorneys know that HR may not know. When your handbook and practices don't specifically address manager accountability and discipline, you create a 2-tiered system that gives managers license to handle situations however they want and becomes evidence of discrimination and retaliation. The EEOC and plaintiffs' attorneys look at patterns. If your managers are handling situations differently without documented consequences, letting some employees get away with something while another employee gets fired for the same behavior, that's proof of unequal treatment. And as every good HR professional knows, lawsuits happen when different people are treated differently. If your handbook has detailed discipline procedures for employees, but nothing holding supervisors accountable to that process, attorneys argue you never intended to hold management accountable and let each manager treat different employees differently for whatever reason, which they will absolutely say was because of illegal discrimination or harassment. Smart HR departments know missing manager accountability sections become the first domino to fall on the path to a lawsuit you're going to struggle to defend. According to employment litigation data, differential treatment cases settle between $75,000 and $200,000. Court records show these claims win when employees can prove some employees got in trouble for something while others didn't. And it usually starts with managers not handling things the same way. Just as you give employees standards for their jobs, you need to hold your managers accountable to good management standards, not just creating schedules and watching the work happen. Here's how it plays out. Employee files discrimination complaint. Attorney reviews your handbook. Attorney discovers detailed employee discipline procedures but 0 manager accountability language. Attorney points to 3 incidents where managers handled similar situations completely differently. Now you have to struggle to explain why everything happened differently. At best, the company looks silly. At worst, a court or the EEOC sees it as discrimination or retaliation. All because we didn't hold our managers accountable to good management practices. Here's the checklist I give every HR team before finalizing their employee handbook. First, create a separate section titled Management Accountability that explicitly states managers and supervisors are held to the same standards as employees and face the same or greater consequences for policy violations. Some companies even have entire dedicated managers' handbooks, and that's something you can consider too. Second, require that any manager who violates company policy must be documented and disciplined according to written procedures, and specify that failure to document manager discipline in and of itself is a violation. Third, include specific language that managers who fail to follow proper discipline procedures, fail to document employee issues, or apply policies inconsistently will face corrective action up to and including termination. Fourth, list common manager violations that trigger discipline, such as failing to report harassment complaints, retaliating against employees who complain, applying discipline inconsistently, failing to maintain required documentation, or violating confidentiality. Middle managers are a huge source of liability for companies because they often forget to report real problems up the chain. Fifth, establish that HR will conduct quarterly audits of manager compliance with handbook policies and document any violations immediately. That protects you from manager accountability gaps, but without this next section, you're still exposed to NLRB violations that cost even more. Your HR team thinks this protects the company's reputation. You want employees to represent you well online. The policy feels like common sense business protection. But here's what catches even experienced HR teams off guard. After the NLRB's 2023 Stericycle decision, most company social media policies are now automatically illegal. There's no gray area. The policies that seemed fine 2 years ago are federal labor law violations right now. The NLRB specifically ruled that handbook policies are presumed unlawful if employees could reasonably interpret them as restricting their right to discuss wages, working conditions, or workplace problems, even on social media. Courts have ruled that vague policies prohibiting negative comments or damaging the company's reputation violate federal law because they could stop protected activity and make an employee think twice before speaking out. According to NLRB enforcement data, unfair labor practice charges based on social media policies result in handbook revisions, back pay for terminated employees, and other monetary awards to make an employee whole again. And because these awards are based on actual employee salaries and benefits costs, those awards can easily get to between $50,000 and $150,000 and even more if more employees are affected. The violation is clear-cut when your policy could reasonably prevent employees from discussing workplace issues. The problem gets worse when managers enforce these illegal policies. Case law shows employees getting fired for posting about low wages or unsafe conditions, and the company's own social media policy becomes the evidence that proves the termination violated federal law. That written policy becomes almost impossible to defend in front of the NLRB. Here's the protocol I recommend to every HR department. First, immediately review your current social media policy. If it includes vague phrases like don't post negative comments, maintain professionalism, don't damage our reputation, or don't criticize management, your policy is likely illegal right now. Second, rewrite your social media policy to explicitly state that nothing in the policy restricts employees' rights under Section 7 of the National Labor Relations Act to discuss wages, hours, working conditions, or other terms and conditions of employment with coworkers or on social media. Third, your policy can only restrict social media activity that is deliberately and maliciously false, egregiously offensive or obscene, discloses actual trade secrets or confidential business information, not just general business information, or violates other laws like harassment or discrimination laws. Fourth, train all managers that employees have the legal right to complain about working conditions, discuss their pay, criticize management decisions, and post about workplace problems on social media, even if it makes the company look bad, as long as they're discussing working conditions with their coworkers. Fifth, before disciplining any employee for social media activity, require HR approval and legal review to ensure the post isn't protected concerted activity under federal labor law. Now your social media policy is compliant, but there's still a documentation gap that plaintiffs' attorneys specifically look for. But here's what's missing. Your handbook doesn't explain what happens when managers skip steps in the progressive discipline process. It doesn't say whether managers can go straight to termination. It doesn't address what to do when a manager bypasses the system entirely. Your HR team thinks the progressive discipline outline is enough. Managers understand the process exists. It feels like they'll follow it because it's written down. But here's what the EEOC sees that catches most HR teams off guard. When your handbook outlines a progressive discipline system but doesn't require managers to actually follow it, employees who get terminated without going through the steps have stronger retaliation and discrimination claims. According to EEOC guidance, if your handbook says you use progressive discipline but managers skip steps or go straight to termination, you create the appearance that you selectively enforce your own policies. When employee A gets all the warnings but employee B gets immediately fired for the same offense, courts see that as evidence of discriminatory intent. EEOC data shows discrimination claims, including failure to follow stated progressive discipline procedures, settle between $60,000 and $120,000. These cases are expensive because your own handbook becomes evidence against you. You wrote down a process, then didn't follow it, which makes it look like you had ulterior motives and the real reason for termination was discriminatory. The violation gets worse when managers handle progressive discipline inconsistently. One manager follows every step religiously. Another manager uses it as a guideline but skips steps for serious issues without defining what qualifies. A third manager follows it for some employees but not others. Now you've documented a fair process but applied it unfairly, which is worse than having no process at all. Here's the system I give every HR team to avoid progressive discipline disasters. First, Add mandatory language to your handbook that explicitly states, managers must follow all steps of progressive discipline unless the violation qualifies as an exception under this policy. Then clearly define what exceptions exist. Typically things like violence, theft, or pretty other serious misconduct. Second, require that any deviation from progressive discipline must be approved by HR in writing before disciplinary action is taken. Specify that managers cannot skip steps without documented justification and HR authorization. Third, establish that if progressive discipline has started for any performance or conduct issue, termination for that same issue requires completion of all prior steps unless circumstances have changed or new violations occurred. Fourth, mandate that managers who skip progressive discipline steps without proper authorization will face corrective action themselves, and specify that terminations conducted outside the progressive discipline process may be reversed and the employee reinstated. Fifth, require HR to audit all terminations quarterly to verify managers followed progressive discipline procedures and document any cases where steps were skipped and why that was justified. Sixth, include clear examples in your handbook of situations that do and don't require progressive discipline so managers understand when they can act immediately versus when they must follow the full process. Make the distinction crystal clear so that there's no room for subjective interpretation. Remember, missing manager accountability sections open you to $75,000 plus differential treatment claims. Illegal social media policies trigger $50,000 plus NLRB violations, and failure to enforce your own progressive discipline system creates $60,000 plus discrimination lawsuits that your handbook helps prove. Here's the math that matters. A comprehensive handbook review and update with legal counsel typically costs $4,000 to $6,000 one time. The average employment lawsuit settlement ranges from $60,000 to $200,000. One missing handbook costs more than 15 complete handbook updates. The math just isn't even close. This is exactly what I review for HR departments before NLRB charges and discrimination lawsuits arrive, because fixing these problems after a complaint could cost 50 times more than preventing them. HR professional, you are the front line when it comes to protecting your company from handbook-based liability. Even the most experienced HR teams can miss critical sections that federal agencies specifically target in their enforcement actions. If your employee handbook was written before 2023, especially if it hasn't been reviewed for NLRB compliance after the Stericycle decision, getting a handbook compliance audit could be the difference between a protective document and a $150,000 federal charge. A proper handbook review can bring you peace of mind, protect your company from regulatory enforcement, and reinforce the excellent work your HR team is already doing. If you're unsure about your current handbook's compliance with NLRB regulations, manager accountability standards, or progressive discipline enforcement requirements, you may want to consult with a qualified employment attorney who can evaluate your specific handbook language. The link to schedule a handbook compliance review is in the description below. Let's make sure your employee handbook follows federal regulations, protects your managers from liability, and shields your business from preventable employment claims. Thanks for watching, and thank you for doing the hard work of building compliant, people-first workplaces.